This is Talking Work. I'm Deborah Ishihara. Today I'm going to talk to one of our Australian lawyers about some recent amendments to the law relating to sex discrimination and sexual harassment. Welcome to Talking Work, the employment law podcast by Jus Laboris. In each episode, we invite a different guest to discuss what's happening in the world of work. If you're an HR professional of any kind, this podcast is for you. Sarah Clarke is a partner in our Australian law firm Cause Chambers Westgarth, and she's here to give us an update on some recent amendments to the Australian anti-discrimination legislation. Sarah, it's always a challenge to find a time that's good for both of us, given the 10-hour time difference between Paris and Melbourne, but we seem to have done it, so good evening.
Hello, Deborah, and it's great to be here, and good morning to you.
Now, it seems that a report was completed into sexual harassment in 2020, containing no fewer than 55 recommendations. Some of those have since been implemented, but the key recommendation, which was to impose a positive duty on employers to eliminate sex discrimination and harassment, was not implemented until now. Sarah, tell us something first of all about the political context for the recent changes, including the positive duty, and the importance of those changes.
Yeah, thanks, Deborah. So there is a lengthy background to these developments, but in short, these recent changes started with a national inquiry into sexual harassment in Australian workplaces back in 2018. And that resulted, as you mentioned, in an almost 900-page report containing these 55 recommendations. And this report is quite infamous in Australia. It's known as the Respect at Work report. While the previous federal government implemented some of the report's recommendations in 2021, the most recent changes are the result of our newly elected Labor government's election promise to fully implement all 55 of those recommendations from that Respect at Work report, and including this cornerstone positive duty. This change is a really significant shift from what has been a reactive and complaint-driven approach to addressing sexual harassment or sex discrimination in the workplace, in favour of a much more proactive assessment and response to the structural and cultural drivers of these kinds of risks in a workplace. It really will require employers now to take positive steps to eliminate or minimise those risk factors.
Okay, so how's the new positive duty defined in the law?
Yeah, so as of the end of last year, these amendments have occurred pursuant to our Sex Discrimination Act. And the positive duty requires employers or a person conducting a business or undertaking, what we call a PCBU, to take reasonable and proportionate measures to eliminate, as far as possible, sex discrimination, sexual harassment, victimisation, and conduct that is prohibited under a new section on hostile workplace environments. So when looking at whether an employer has actually taken reasonable and proportionate measures, the kinds of factors that might be taken into account include the size and nature of the employer, the practicability and costs of steps to eliminate that kind of conduct in the workplace, and other matters such as whether a workplace has complied with guidance materials provided by our Human Rights Commission.
Mm-hmm. So in some countries, health and safety law tends to take up the slack where anti-discrimination law is found to be insufficient. Are there any existing duties under health and safety law in Australia that are relevant to questions of bullying and harassment, and are they helpful?
Yeah, this is a really interesting question, Deborah. The intersection between these new laws and our existing workplace health and safety laws has been the topic of much discussion and debate. Under our Australian work health and safety laws, employers or PCBUs have a primary duty to ensure, so far as is reasonably practicable, the health and safety of workers while they're at work and of others who may be affected by the carrying out of that work. Health and safety in this context absolutely includes psychological health and safety, and we have seen regulators become much more active in recent years in the context of bullying and stress-related compliance activities, as well as in relation to sexual harassment in the workplace. So there's certainly this overlap between that existing primary duty and this new positive duty. And indeed, the basis for the previous federal government refusing to actually implement the recommendation for a positive duty was that such a duty already existed under existing health and safety laws. While the two duties are intended to operate in a mutually reinforcing way, Some commentary out of a recent Senate report certainly makes clear that the two are to be viewed as separate frameworks, and that these compliance regimes, if you're discharging one, it doesn't necessarily mean you'll be complying with the other. And honestly, I don't think we will have real clarity on that issue until the matter is tested in our courts. So if we kind of consider that, Deborah, in practical terms, the new positive duty requires employers to adopt a safety and risk prevention lens throughout the workplace, which they should be familiar with these existing work health and safety duties. However, given this is what we call in Australia a psychosocial hazard, what organisations are currently doing with respect to broader work health and safety duties won't necessarily be sufficient. Organisations are really going to need to do much more in the context of risk assessments, specifically looking at cultural and systemic drivers of sexual harassment in order to meet this new positive duty.
So, Sarah, I gather it's now possible for employees to claim against their employer for creating a hostile work environment. First of all, what constitutes a hostile work environment, and what do employers need to do to make sure their workplace is not one?
Yeah, so this is a new limb under the Sex Discrimination Act, and a hostile work environment is one which is offensive, intimidating, or humiliating to a person because of their sex or because of characteristics generally attributed to their sex. It's often an issue for women in male dominated workplaces. So, the kinds of conduct we're looking at are the displaying of pornographic materials around an office, or engaging in general sexualised banter or innuendo, telling offensive jokes that might create that hostile workplace environment. Essentially, the section is really designed to stamp out and eliminate that kind of inappropriate behaviour that isn't necessarily directed towards an individual but is harmful nonetheless.
Hmm. Back to the positive duty then. I imagine the starting point for employers is going to be to identify any weak points by doing a risk assessment. Can you tell me how employers should go about this and what the assessment should cover?
Yeah, adopting a risk management approach and conducting these risk assessments will be absolutely critical to discharging the positive duty. Moving forward, as I mentioned, the approach required by employers really needs to be a collaborative one. So, with various functions, human resources, diversity and inclusion teams, work health and safety teams, even legal functions across the workplace will need to come together to identify cultural drivers of sexual harassment and discrimination in the workplace, and then the measures and controls needed to address them. So, if we look at what a risk management approach really involves, it's about first and foremost identifying risks, and that's about finding out what are the causes of sexual harassment in your workplace and where could it occur. Secondly, it's about assessing that risk. And that requires consideration of how much harm could be caused by the risk to the individual and the organisation. And it requires an assessment of the nature of that harm and the likelihood of it happening. You then move into the implementation of control measures to eliminate those risks. And finally, and perhaps most importantly, is monitoring and reviewing the effectiveness of the controls and adapting or improving them where necessary. Identifying risks of sexual harassment in a workplace can actually be really challenging, and it does require quite a deep dive into an organisation. And key to this is data. It absolutely will assist an organisation to determine where these risks are coming from. So, information from surveys, consultation with staff, exit interviews, grievance and complaints data, feedback on managers, data and workforce composition, really, really important to that process. And the kinds of risks we're thinking about, Deborah, are things like, have we got a workplace where there is hierarchy with large power differentials between employees? Have we got a workplace where we've got people who are doing high value work, but where there may be a lack of accountability for unacceptable behaviour? Have we got a workplace where people are geographically or socially isolated? Do we have a male-dominated workforce? Do we have younger workers? So there are a number of different risks that need to be unpacked by an organisation for the purposes of this risk assessment.
And do you have any tips, Sarah, for employers about how to address the sort of outcome they might find to their risk assessment?
Yes, absolutely, Deborah. We've been doing a lot of work in this area of late for obvious reasons. And as mentioned, employers will really need to be looking at the implementation of these control measures in response to the identified risks. So, for example, an employer's risk assessment may identify, as the example I pointed out earlier, about power imbalances. And what kind of control measures are we looking at putting in place to address that? Things like gender equality and diversity targets across areas of the organisation, including senior leadership positions and the board, providing gender sensitive development training, building gender equality benchmarking into remuneration reviews, the way you recruit. I mean, there's a lot of different things that can be fed into those control measures. And employers really should use risk assessments as an opportunity for continual review and improvement. These are not static documents, and that can't be stressed enough, in order to satisfy this positive duty and to really target sexual harassment and discrimination in the workplace.
Hmm. And of course, laws are usually only as good as their enforcement mechanisms. So, how good are those in terms of the new positive duty, Sarah?
This is a real shift, Deborah, actually. So by the end of this year, the Australian Human Rights Commission will have quite expansive powers of monitoring and enforcement in relation to the positive duty. And that, as I say, is a really significant shift from its present powers and role. It will be given powers to inquire into compliance with the positive duty. It will be able to issue compliance notices, to compel the production of documents, and to enter into what we call enforceable undertakings with employers about their obligations to comply with the duty. In addition to that, they will also have, and in fact, this is already underway, a new broad power to inquire on their own motion into any matter that may relate to systemic unlawful discrimination. And these powers can all be backed up through court orders. So it also is also very important to note that these changes in terms of enforcement are not intended to exclude or limit the operation of state or territory laws. So it means that a single sexual harassment complaint may still be investigated by a work health and safety regulator in a state or territory, or indeed the relevant Human Rights Commission in a state or territory. So we understand at the moment from the regulators that the intention is not to have duplication of efforts across regulators, but there is certainly concern amongst employers about being approached by multiple regulators about a matter arising in their workplace.
Hmm. So, for completeness, Sarah, are there any other legal provisions that are relevant to sexual harassment in Australian workplaces?
Yes, there are, Deborah. There is a lot for employers to get across at the moment. Beyond the work health and safety duty I mentioned earlier and existing anti-discrimination laws, there has been some important changes under our Fair Work Act, which is Australia's primary piece of employment legislation. So this has very recently only been amended to expressly prohibit sexual harassment in connection with work. As is the case under anti-discrimination laws, employers may be vicariously liable for sexual harassment perpetrated by their workers unless they have taken all reasonable steps to prevent the harassment. So the significance of including a prohibition against sexual harassment in employment legislation, in addition to what already exists, really is about enforcement. Complainants will now be able to apply to what is our Fair Work Commission. It is the tribunal that administers the Fair Work Act, and that is to obtain what we call a stop sexual harassment order or seek that the tribunal otherwise deal with the dispute. So where this fails, the parties may agree to arbitrate the dispute, and the tribunal will have broad powers to order compensation and other remedies.
Great. Well, thank you so much, Sarah, for that very interesting update on what's going on in Australia at the moment. You can find Sarah's contact details in the notes to this episode, and mine are there too. You're always welcome to contact me on anything to do with employment law. And if you need to know who to contact in a particular country, say, I'll put you in touch with the right person. Do browse around our website, by the way. There's loads of information there on all sorts of employment-related topics at usetheborus.com. Thanks for listening, and join us again. That's it for this episode of Talking Work, but we'll be back very soon with more insights from our guests from around the world. If you've enjoyed this episode, don't forget to subscribe to the podcast. You can also visit usetheborus.com to access all our content, resources and tools.